Chapter 5 discussions will cover legal liability for certified public accountants, as well as actions available to the profession and practitioners to minimize the liability. At the end of Chapter 5, you should be able to do the following. You should be able to understand the litigious environment in which certified public accountants practice. Be able to explain why the failure of financial statement users to differentiate among business failure, and audit risk has resulted in litigation against CPAs. You should be able to use the primary legal concepts and terms concerning accountants' liability as a basis for studying legal liability of auditors, and you should be able to describe the accountant's liability to clients and the related defenses. In addition, at the end of Chapter 5, you should also be able to describe an accountant's liability to third parties under common law and the related defenses to it. Be able to describe an accountant's civil liability under the federal securities laws and the related defenses. You should also be able to specify by the end of Chapter 5 what constitutes a criminal liability for accountants, and lastly, be able to describe how the profession and individual CPAs can reduce the threat of litigation. This chapter highlights the environment in which certified public accountants operate in the profession and in the industry. We will begin by understanding the litigious environment in which CPAs practice. Professionals, including certified public accountants, are held to a high level of performance. Under common law, audit professionals have a responsibility to fulfill implied or express contracts with their clients. Should auditors fail to provide the services or not exercise due professional care in their performance of the service, the auditors may be liable to their clients, and in certain circumstances may also be held liable to third parties other than their clients. In addition to common law liability, auditors may be held liable to third parties under statutory laws such as the Securities Act of 1933, the Securities Exchange Act of 1934, and the Sarbanes-Oxley Act. Despite the efforts by the profession to address legal liabilities of certified public accountants, both the number of lawsuits and the size of the awards to plaintiffs remain high, including lawsuits involving third parties under both common law and the federal securities acts. The following factors are major contributors to the increasing trend in litigation against CPAs: the growing awareness by the public and users of financial statements of the responsibilities of CPAs, the increased effort by the Securities Exchange Commission to protect investors' interests, the increased complexity of auditing and accounting functions due to the increasing size of business, the globalization of business as well as the complexities of business operations and financing transactions. Another contributing factor to the increasing trend in litigation against CPAs is also the tendency of society to accept lawsuits by injured parties against anyone who might be able to provide compensation regardless of who was at fault. Reasons for increased litigation against certified public accountants also include the global recession and tough economic times resulting in business failures. The large civil court judgment against CPA firms awarded in a few cases that encourages attorneys to provide legal services on a contingent fee basis. The CPA firms willing to settle legal cases out of court in an attempt to avoid costly legal fees and adverse publicity rather than pursuing resolution through judicial process. And lastly, the reason for increased litigation against CPAs is the difficulty of judges and jurors in understanding technical accounting and auditing matters. The failure of financial statement users to differentiate among business failure, audit failure, and audit risk has resulted in litigation against certified public accountants. In the next few slides, we are going to discuss about business failure, audit failure, and audit risk. Many certified public accountants and legal professionals believe that a major cause of litigation against practitioners is the lack of understanding by a financial statement user of the following two concepts. The first concept is the lack of understanding of the distinction between a business failure and an audit failure, and the user's lack of understanding of the distinction between an audit failure and audit risk. Given that, what is a business failure? A business failure occurs when a business is unable to repay its lenders or unable to meet the expectations of investors because of economic or business conditions such as a recession, poor management decisions, or unexpected competition in the industry. In contrast, an audit failure occurs when the auditor issues an incorrect audit opinion because the auditor did not comply with the requirements of auditing standards. What is the difference between audit failure versus audit risk? The audit risk represents the possibility that the auditor concludes after conducting an adequate audit that the financial statements were fairly stated when in fact they were materially misstated. However, audit risk is unavoidable because auditors gather evidence on a test basis and because well-concealed frauds are extremely difficult to detect. For example, an auditor may have fully complied with auditing standards and still fail to uncover a material misstatement due to fraud. Accounting professionals tend to agree that in most cases, when an audit failed to uncover material misstatements and the wrong type of opinion was issued, it is appropriate to question whether the auditor exercised due care in performing the audit. An auditor's failure to follow due care often results in liability and, when appropriate, damages against the CPA firm. If a business failure happens and the financial statements are later to have been determined to have been misstated, users of the financial statements may claim that the auditor was negligent even if the audit was conducted in accordance with auditing standards and the auditor performed the audit with professional due care. This conflict between financial statement users and auditors often arises because of an expectation gap between the user and the auditor. The expectation gap contributes to the amount of litigation against auditors. The expectation gap refers to the difference between what an auditor's responsibilities are and what the financial statement users expect from the auditor. Most auditors believe that an auditor's responsibility is to perform the audit in accordance with auditing standards. However, many users believe that the auditor guarantees the accuracy of the financial statements, and some users even believe that the auditor guarantees the financial viability of the business. Fortunately for the auditing and attestation profession, legal courts continue to support the auditor's view that the auditor's responsibility is not to guarantee the accuracy of the financial statement nor to guarantee the financial viability of the business, but the auditor's responsibility is to perform the audit in accordance with auditing standards. The audit and attestation profession must continue to educate financial statement users about the role of auditors as well as the distinction between business failure, audit failure, and audit risk. In the next few slides, we are going to cover legal concepts affecting liability. Most of the major litigation against CPA firms have dealt with audited or unaudited financial statements. We will begin by discussing several legal concepts pertinent to litigation involving certified public accountants. Some basic legal concepts involved in determining liability includes the following: the prudent person concept, the liability for the acts of others, the lack of privileged communication, the legal terms affecting CPA's liability, and lastly, the sources of legal liability. Let us discuss about the first legal concept on the list, which is the prudent person concept. The prudent person concept pertains to the auditor's compliance with the standard of professional due care when performing audit and attestation services. There is an agreement within the profession and the courts that the auditor is not a guarantor or insurer of financial statements. The auditor is only expected to conduct the audit with due care. The next concept is the liability for the acts of others. The basic legal concept related to the liability for the act of others pertains to the liability of a partner in a CPA firm for the work of others on whom they rely under the laws of agency. If an employee of a CPA firm performs improperly in doing an audit, the partners of the CPA firm can be held liable for the employee's performance. Moving on, we are going to talk about next the lack of privileged communication concept. Under common law, confidential discussions between a client and the auditor cannot be withheld from the courts. However, a CPA can refuse to testify in a state with privileged communication statutes, with the exception of federal courts where privileged communication cannot be withheld in federal court. We will look at the legal terms affecting CPA's liability in the next slide. Do take note that there are 4 sources of legal liability. The first is the liability to clients, followed by the liability to third parties under common law, then the civil liability under federal securities laws, and lastly is criminal liability. In here, we have several common legal terms that affect CPA's liability. Let us take a moment to review some of the legal terms in this table, such as the terms related to negligence and fraud. When the auditor has failed to conduct an adequate audit, liability may depend on the level of negligence, being from ordinary negligence to gross negligence, to constructive fraud, or what is also known as recklessness, and lastly, when there is knowledge of the financial statement to be false and there is intent to deceive the user of the statements. The terms related to contract law involves the breach of contract and third-party beneficiary. For example, a CPA firm may be liable under a breach of contract when a CPA firm fails to deliver a client's tax return on the agreed upon date. In addition, a CPA firm may also be liable to a third-party beneficiary who does not have privity of contract but is known to the contracting parties and is intended to have certain rights and benefits under the contract. Other legal terms affecting CPA liability is common law. Common law are laws that have been developed through court decisions rather than through government statutes. Statutory law are laws that have been passed by the U.S. Congress and other governmental units. Also note the distinction in this table between joint and several liability as well as separate and proportionate liability, because the amounts assessed for damages against a CPA will likely vary greatly between these two approaches when courts assess damages against the certified public accountant or the CPA firm. Please do read this table carefully, and you will find table 5-1 on page 119 of your textbook. In here, we have examples of potential claims of each of the four sources of auditors' legal liability. For liability to client, an example would be when a client sues an auditor for not discovering a material fraud during the audit. For liability to third parties under common law, an example would be when a bank sues an auditor for not discovering that a borrower's financial statements are materially misstated. In this particular example, the bank does not have privity of contract, but is known to the contracting parties and is intended to have certain rights and benefits under the contract. Consequently, as a third-party beneficiary, the bank in this particular example can sue an auditor for failure to discover the borrower's materially misstated financial statements. For civil liability under federal security laws, an example would be when a group of stockholders sues the auditor for not discovering a publicly held company's materially misstated financial statement. And lastly, for criminal liability, an example would be when a federal government prosecutes an auditor for knowingly issuing an incorrect audit report. Please read this figure carefully, and you can find figure 5-1 on page 120 of your textbook. In the next few slides, we will discuss about the accountant's liability to clients and the related defenses. The most common source of litigation against certified public accountants is litigation from clients. A typical lawsuit brought by a client involves negligence in the conduct of the audit. The principal issue in cases involving alleged negligence is usually the level of care required. In audits, a failure to meet auditing standards by the auditor is often conclusive evidence of negligence. In here, we have an example of a case that raised the question of negligent performance by a CPA firm. The case is between Senko Incorporated versus Sedman and Sedman. The source of legal liability for the CPA firm in this particular example is the liability to clients. The case between Senko Incorporated versus Sedman and Sedman involves alleged negligence by the auditor in failing to find fraud. In the legal suit by Senko's management, the auditor was able to successfully argue that it was not negligent act by the auditor when the fraud was not identified, but rather it was due to the previous management's deceitful actions that prevented the auditor from uncovering the fraud. You can find figure 5-2 on page 120 of your textbook. Auditors normally use one or a combination of 4 defenses when there are legal claims filed by a client. The defense of lack of duty to perform service, the defense of non-negligent performance, the defense of contributory negligence, and lastly, the defense of absence of causal connection. Under the defense of lack of duty to perform service, what this defense means is that the auditor claims that there was no implied or express contract to perform the service. The CPA's use of an engagement letter provides a basis to demonstrate a lack of duty to perform. We will discuss engagement letters on Chapter 8. Under the defense of non-negligent performance, what this defense means is that an auditor claims that the audit was performed in accordance with auditing standards. The auditing standards make it clear that an audit is subject to limitations and cannot be relied on for compliance assurance that all misstatements will be found. Even if there were undiscovered misstatements, the auditor is not responsible if the audit was conducted properly. In contrast, under the contributory negligence defense, this defense means that an auditor claims that the client's own actions either resulted in the loss that is the basis for damages, or the client interfered with the conduct of the audit in such a way that prevented the auditor from discovering the cause of the loss. And lastly, under the defense of absence of causal connection, what this defense means is that in order to succeed in an action against the auditor, the client must be able to show that there is close causal connection between the auditor's failure to follow auditing standards and the damages suffered by the client. In here we have an example of a legal case between 1136 Tenants versus Max Rosenberg and Company. The case involves a claim by 1136 of the CPA's failure to uncover fraud in unaudited financial statement. Although the certified public accountant in this particular example was never engaged to conduct an audit for the 1136 Tenants Corporation, the CPA was found liable for failing to detect an embezzlement scheme conducted by one of the client's managers. The lack of a clear understanding between the client and the CPA to the exact nature of the services to be performed by the CPA resulted in a liability to the client by the CPA in this example. As noted, because of this legal case, engagement letters between a client and a CPA firm was developed as a result. Now, CPA firms and clients normally sign engagement letters which are required for audits to formalize the certified public accountant and client's agreement about the services to be provided, the fees to be charged, and the timing of the audit. A privity of contract can exist without a written agreement, but an engagement letter defines the contract more clearly. You can find Figure 5-3 on page 121 of your textbook. We will continue our discussion of legal liability of certified public accountants by discussing the accountant's liability to third parties under common law and its related defenses. In addition to being sued by clients, certified public accountants may also be liable to third parties under common law. Third parties include actual and potential shareholders of a corporation, vendors, bankers or creditors, employees, and customers of the CPA firm. A CPA firm may be liable to third parties if a loss was incurred by the claimant due to reliance on misleading financial statements that were audited by the certified public accountant. The leading precedent-setting legal case in audit involving third-party liability was the legal case between Ultramaris Corporation versus Touche. The Ultramaris Corporation versus Touche legal case established what is now known as the Ultramaris Doctrine. Under the Ultramaris Doctrine, although an auditor is negligent, the auditor negligence is insufficient for liability to third parties because of the lack of privity of contract between the third party and the auditor, unless the third party is a primary beneficiary to the contract. You can find Figure 5-4 on page 122 of your textbook. In subsequent court decisions, courts have broadened the Ultramaris Doctrine to allow recovery by third parties who are considered foreseen users. Foreseen users are members of a limited class of users that the auditor knows will rely on the financial statements. For example, in the case of Rush Factors versus Levin, as seen in Figure 5-5, the lender asked the auditor to audit the financial statements of a borrower. The auditor issues an unqualified opinion on the financial statements, indicating the company was solvent when in fact it was not. The lender loaned the borrower money, suffered subsequent loss, and consequently sued the auditor for recovery. The court in this particular example found in favor of the lender, and the auditor was held liable for ordinary negligence for the audit of the financial statement that are relied on by actually foreseen and limited classes of persons. You can find Figure 5-5 on page 120 of your textbook. Courts have generated several different interpretations to the concept of foreseen users. At present, the three leading approaches taken by the courts that have emerged is credit alliance, the approach in terms of restatement of torts, and foreseeable users. In the legal case of Credit Alliance versus Arthur Andersen, the court's approach was to uphold the basic concept of privity established by Ultramaris and stated that for an auditor to be liable, an auditor must know and intend that the work must be evidenced by the auditor's conduct. The other approach used by the court is the restatement torts. The restatement rule is that foreseen users must be members of a reasonably limited and undefinable group of users who have relied on the certified public accountant's work, even though those persons were not specifically known to the certified public accountant at the time the work was done. An example for this would be the legal case between Rouge factor versus Levin that we previously discussed in the preceding slide. The broadest interpretation of third-party beneficiaries is the concept of foreseeable users. Under this concept, any users who the auditor should have reasonably been able to foresee as a likely user of the client's financial statements have the same rights as those with privity of contract. Table 5-2 is a summary of the different approaches to third-party liability under common law that I just discussed. You can find Table 5-2 on page 123 of your textbook. 3 of the 4 defenses available to auditors in lawsuits against them by clients are also available in third-party lawsuits. The 3 defenses are the defense of lack of duty to perform service, the defense of non-negligent performance, and lastly, the defense of absence of causal connection. A lack of duty defense in third-party lawsuits contends the lack of privity of contract. If the auditor is unsuccessful in using the lack of duty defense, the preferred defense in third-party lawsuits is non-negligent performance. If the auditor conducted the audit in accordance with auditing standards, that eliminates the need for the other defenses. Now, unfortunately, for non-negligent performance defense, this defense can be difficult to demonstrate to a court, especially in jury trials when lay people with no accounting experience make up the jury. And lastly, the defense of absence of causal connection in third-party lawsuit often means non-reliance on the financial statements by the user. The next topic we will discuss is the accountant's civil liability under the federal security laws and the related defenses for it. The greatest growth in certified public accountant liability litigation has been under the federal securities law. The Securities Act of 1933 deals only with the reporting requirements for companies issuing new securities, including the information in registration statements and prospectuses. The only parties who can recover from auditors under the 1933 Act are the original purchasers of the securities. The amount of potential recovery equals the original purchase price less the value of the securities at the time of the lawsuit. Section 11 of the 1933 Act defines the right of third parties, which are as follows. First, any third party who purchased securities described in the registration statement may sue the auditor for material misrepresentations or omissions in audited financial statements included in the registration statement. Second, third-party users do not have the burden of proof that they relied on the financial statements or that the auditor was negligent or fraudulent in doing the audit. And lastly, the auditor has the burden of demonstrating as a defense that an adequate audit was conducted or all or portion of the plaintiff's loss was caused by factors other than the misleading financial statements. In summary, the 1933 Act is the only common or statutory law where the burden of proof is on the defendant, which in this particular case would be the auditor. Furthermore, the auditor under the 1933 Act is responsible for making sure that the financial statements are fairly stated beyond the date of issuance up to the date the registration statement becomes effective, which can be several months later. In here, we have an example of a certified public accounting firm that was held liable for a lack of due diligence required under the Securities Act of 1933 when performing its review of events subsequent to the balance sheet date. The legal case of Escott versus Barclays Construction Corporation brought two changes in the audit practice. First is the change in auditing standards to require greater emphasis on procedures that the auditor must perform for events subsequent to the balance sheet date. The second noteworthy change to the audit practice is that greater emphasis began to be placed on the importance of the audit staff in understanding the client's business and industry. You can find figure 5-6 on page 125 of your textbook. The liability of auditors under the Securities Exchange Act of 1934 deals with the audited financial statements issued to the public in annual reports submitted to the Securities Exchange Commission by publicly held companies. It also deals with subsequent reporting by the public company, such as quarterly information or other reporting information filed with the SEC. Section 10 and Rule 10b-5 of the Securities Exchange Act of 1934 are often called the anti-fraud provision of the 1934 Act, as they prohibit any fraudulent activities involving the purchase or sale of any security. Rule 10b-5 applies not only to direct sellers, but also to accountants, underwriters, and others involved with the public company. CPAs and auditors can be held liable under Section 10 and Rule 10b-5 of the Securities Exchange Act of 1934 if they intentionally or recklessly misrepresent information intended for third-party use. In here, we have an example of a legal case related to the Securities Exchange Act of 1934. In the case of Hochfelder versus Ernst, the United States Supreme Court ruled that scienter, which is the knowledge and intent to deceive, is required before a certified public accountant can be held liable for violation under Rule 10b-5 of the Securities Exchange Act of 1934. You can find figure 5-7 on page 125 of your textbook. In contrast, in the Solitron Devices legal case, the Court of Appeals ruled that reckless behavior on the part of the auditor was sufficient to hold the auditor liable for violation of Rule 10b of the Securities Exchange Act of 1934. The knowledge and deceit standard was argued to have been met in which the auditor knew all the relevant facts but made poor judgments in the performance of the audit. However, in subsequent litigation cases under Rule 10b-5, the court have ruled that poor judgment is not proof of fraud. An example of such ruling was made with the Worlds of Wonder and the Software Toolworks legal cases. The same three defenses available to auditors in common law litigation by third parties are also available for lawsuits under the 1934 Act. These defenses are the defense based on the lack of duty, defense based on non-negligent performance, and lastly, defense based on the absence of causal connection. In here, we have the summary of the Solitron Devices legal case where the Court of Appeals ruled that reckless behavior on the part of the auditor was sufficient to hold the auditor liable for violation of Rule 10b-5 of the Securities Exchange Act of 1934. As we have discussed this in the previous slide, we will move on to the next presentation slide. You can find figure 5-8 on page 127 of your textbook. Closely related to auditor's liability is the Security Exchange Commission and Public Company Accounting Oversight Board authority to sanction certain professionals who are involved with publicly held companies. The SEC and the Public Company Accounting Oversight Board have the power in certain circumstances to sanction or suspend practitioners from doing audits for SEC companies. The SEC Rules of Practice and the Public Company Accounting Oversight Board Rules of the Board permit them to temporarily or permanently deny a certified public accountant or CPA firm from being associated with financial statements of public companies because of a lack of appropriate qualifications or having engaged in unethical or improper professional conduct. Another significant congressional action affecting both CPA firms and their clients was the passage of the Foreign Corrupt Practices Act of 1977. This act makes it illegal to offer a bribe to a foreign official of a foreign country for the purpose of exerting influence or retaining business. The prohibition against payments to foreign officials is applicable to all U.S. domestic firms, regardless of whether they are publicly or privately held, and to all foreign companies filing with the Security Exchange Commission. The Act also requires SEC registrants under the Security Exchange Act of 1934 to meet additional requirements of reasonably complete and accurate records, as well as an adequate system of internal control. Although the provisions of the Act do remain in effect, the provisions related to accounting records and internal control are largely superseded by the more stringent requirement of the Sarbanes-Oxley Act of 2002. The Sarbanes-Oxley Act of 2002 greatly increases the responsibilities of public companies and their auditors. The Act requires the auditor to provide an opinion on the effectiveness of internal control over financial reporting. As a result, the auditors may be exposed to legal liability related to their opinions on internal control. The Public Company Accounting Oversight Board also has the authority to sanction registered CPA firms for any violations of the Act. In here, we have a summary of the sources of auditors' liability to clients and others, which are the liability for breach of contract under common law, liability to third parties under common law, and liability to third parties under the 1933 and 1934 Securities Exchange Act. The table illustrates the strict burden on auditors to defend themselves under the 1933 Act. Liability to third parties under common law and the 1934 Act depends on the degree of negligence. Liability to third parties under common law also depends upon the jurisdiction and whether the third party is a primary beneficiary or known user of the financial statements. You can find Table 5-3 on page 129 of your textbook. In here, we have a summary of the defenses available to the auditor. If the auditor is unable to prove a lack of duty to perform the service, the preferred defense is generally non-negligent performance. The defenses listed in this summary have been discussed previously in the course presentation. I'm not going to go through it again, but I do recommend that you read through it carefully, and you can find table 5-4 on page 129 of your textbook. We have discussed so far the accountant's liability to clients, the accountant's liability to third parties, and the accountant's civil liability under the federal securities law. The next topic we will cover is the criminal liability for accountants. Certified public accountants can be found guilty for criminal action under both federal and state laws. Under state law, the most likely statutes to be enforced are the Uniform Securities Acts, which are similar to parts of the Security Exchange Commission rules. The more relevant federal laws affecting auditors are the 1933 and 1934 Securities Acts, as well as the Federal Mail Fraud Statute and the Federal False Statement Statute. All of this make it a criminal offense to defraud another person through knowingly being involved with false financial statements. In addition, the Sarbanes-Oxley Act of 2002 made it a felony to destroy or create documents to impede or obstruct a federal investigation. Under the Sarbanes-Oxley Act, a person may face fines and imprisonment of up to 20 years for altering or destroying documents. These provisions were adopted following the United States versus Anderson case in 2002. In here, we have a summary or an example of the legal case between the United States versus Anderson. The government charged Anderson with obstruction of justice for the destruction and alteration of documents related to Anderson's audit of Enron. This is an example of criminal liability against an auditor, in this case a certified public accounting firm. This case teaches us several critical lessons. First, the lesson that an investigation in the integrity of management is an important part of deciding on the acceptability of clients and the extent of work to perform by an auditor. As discussed in Chapter 4, independence by all individuals on the engagement is essential, especially in a defense involving criminal actions. The third lesson is that transactions with related parties require special scrutiny because of the potential for misstatement. Accounting principles cannot be relied on exclusively in deciding whether financial statements are fairly presented. The substance of the statements, considering all facts, is required. And lastly, the potential consequences of the auditor knowingly committing a wrongful act are so severe that it is unlikely that the potential benefits can ever justify the actions. You can find figure 5-9 on page 130 of your textbook. We have covered the accountant's liability. The next discussion will be on how the profession and individual certified public accountants can reduce the threat of litigation. The American Institute Certified Public Accountant and the profession as a whole can do a number of things to reduce practitioners' exposure to legal liability. Legal liability can be reduced by seeking protection from non-meritorious litigation, by improving auditing to better meet users' needs, and lastly by educating users about the limits of auditing. Some specific activities include standard and rule setting by the International Auditing and Assurance Standard Boards. the AICP and Public Company Accounting Oversight Board. The continuous opposition of CPA firms of unwarranted lawsuits, even if in the short run the costs of winning are greater than the cost of settling. The sanctions of members by the AICP and Public Company Accounting Oversight Board for improper conduct and performance. And lastly, the profession continues to lobby for changes in law or pursue litigation reform. The passage of the Private Securities Litigation Reform Act of 1995 and the Securities Litigation Uniform Standards Act of 1998 significantly reduced potential damages in federal securities-related litigation by providing for proportionate liability in most instances. Practicing auditors may also take specific actions to minimize their own liability. Some of the more common actions are as follows. The auditor only deals with clients that possess integrity. The auditor maintains independence. The auditor understands the client's business. The auditor performs quality audits. The auditor documents the audit work properly. And lastly, the auditor exercises professional skepticism. It is also important for certified public accountants to carry adequate insurance and to choose a form of organization that provides some form of legal liability protection to CPA owners. In the event of actual or threatened litigation, an auditor should consult with experienced legal counsel. We have reached the end of Chapter 5 discussions. In this chapter, we covered legal liabilities facing the certified public accountant profession, defenses against litigation, and specific activities that an auditor or CPA firm may take to reduce liability. Please complete the required evaluation method for Chapter 5 as it will be part of your final grade. Homework and quiz are to be submitted on the specified due date. Use Blackboard and Pearson's MyLab to complete your homework and quiz. You have reached the end of the course presentation for Chapter 5. Please access the video for Chapter 6 for the next presentation of the course.